With lordship indulgence, may I make a mention of item number 2 and 3? It's a part heard matter, lordship.
Yeah.
If it is not inconvenience to the honorable court, would it be taken up after 11:30, lordship, today? Deeply obliged, lordship.
My lord, may I have your lordship's kind leave
Yeah.
to mention item number 18
1
of the supplementary list.
Yes.
My lord my lord's pleasure was that I appear personally before your lordships, but till yesterday morning it was not appeared in the daily list. My lord, after 8 p.m. I got to know it appeared in the supplementary list, so I could not buy any ticket. So may it appear next to it, subject to your convenience, any day, so that I can come and finish the matter. It's a long pending matter, my lord, and my written argument is also ready.
Have we informed the other side?
I am
My lord,
here.
yes, my lord.
We are not informed, but we are here.
I have informed them.
And another matter, this connected matter, Mr. Chaudhary is appearing in that.
Yes, I have taken the consent, my lord. That will be mentioning, I informed, lord.
Any date, my lord.
Which date of your convenience?
My lord, Wednesday, next Wednesday, my lord.
When is the next Wednesday?
Lordship.
My lord, in the daily list, my lord.
That will be next Wednesday, discount code. The request is non-consequential discount code.
Another lordship.
March of late, March of.
8th of May.
My lord.
My lord, I have an urgent matter, may kindly be listed tomorrow. My lord, a full heard judgment has been totally changed on the basis of filing a review petition, which is not permissible matter. So we have urgent.
Judgment?
Judgment order was decided after hearing both the parties at length.
Okay.
But thereafter, a review petition was filed, it is totally reversed, which is not allowed. So lordship may kindly take up this matter.
What is the urgency of tomorrow?
Tomorrow, my lord, yes.
What's the urgency of tomorrow?
Urgency because, my lord, if that order is implemented, I shall be out of the post of Secretary of PDP. Unless it is annulled or set aside.
Thursday.
Thursday,
Day after
When-
tomorrow? Day after tomorrow.
my lord, obliged.
Thursday.
After.
May it please, my lord. My lord, with due consent of the other side, I beg to mention item number 13 of the daily list, my lord. I'm appearing for the petitioner. My lord, I seek accommodation of 1 week only, my lord.
It's an old matter.
My lord, what had happened is there were a bunch of petitions filed all over the country challenging the Payment of Bonus Act and its retrospective effect. The same petitions were all transferred to the Supreme Court, my lord. Supreme Court, in the meantime, by an order in March 2022, has dismissed all the petitions, the transfer petitions, directing the high courts, individual high courts, to decide the writ petitions on merit, my lord. So, my lord, 1 week time may be granted, my lord.
Any other high court has decided till so far?
My lord, one affidavit has been filed by the respondent, my lord, saying that Patna High Court has in fact dismissed one of the writ petitions which has been filed. My lord,
Same
but
issue.
yes, my lord, but the order has not been enclosed, my lord. Only the operative part has been quoted in the affidavit.
The details of the
No, my
case
lord.
is not there.
No, my lord, not in the affidavit, my lord, filed.
Next week, after a week.
Obliged.
Daily list for orders item 1.
Appointment. I have the instruction, my lord. Appointment letter has already been issued to her.
Where is the copy of that?
Copy of the appointment letter is not with me, my lord. The communication is with me. My lord, they have communicated me to because my lord, in the last hour of the yesterday, appointment letter has been issued. That is why,
Is
my
there
lord.
any information? Do you have any information?
My lord, because of the model code of conduct, my lord, my lord, they have taken to get the approval from the election commission. And after getting the approval, my lord, appointment letter has been issued in the yesterday evening.
copy enclosed.
Copy enclosed, but my lord, they have informed me, my lord, they will serve, my lord, furnish the copy today only, my lord. Yesterday, my lord, evening, it has been issued.
Tomorrow,
Tomorrow,
place it on record.
my lord.
Tomorrow.
Item 2.
Yeah. Yes. We'll await for 2 more weeks. Await return of notices of the respondents for 2 more weeks. Answered respondents for 2 more weeks.
For admission, item 5.
India. Really, lordship, the other day, your lordship desired to see the notification of 5 years that we have collected, but it is a little dirty because and recently we could not collect it from the website. So 5 years, lordship may kindly see the next page. Point number 2, next page. The term of the president and vice president shall be for 5 years. In case of any vacancy arising out of death, That-
Which provision here? Terms and vacancy of the management of development committee. Yes, the term of the president. and the-
5 years.
We have 65 years. It's.
So
So this.
regarding other matters, there is no dispute, my lord. Only regard, now lordship may kindly see page 31, my lord. 31. In the middle portion, serial number 1, the president and vice president of the SMDC should not be more than 65 years of age. So he cannot be more than 65 years of age. Page 31.
Admittedly, at the date of nomination, he has crossed the age of 65 years. On 9/1/2023, he has crossed the age limit of 65 years. So accordingly, he was removed. I mean, from the post of president.
I don't think. Suppose any person
Yes, sir.
is appointed as this president of the SDMC, SMDC at the age of 64 years. So he would continue up to what date?
Then obviously he can continue up to completion of his term, my lord.
5 years.
Yes, my lord. Because at the time of appointment, he should not be more than 65. Here is a case where at the time of appointment, he has crossed the age of 65, my lord.
No, no. My learned friend is perhaps not gone through the record. At that time, I was 64 years.
At
The
that time
kindly see
you
page-
applied- You applied at the time you were within age.
Yes,
Yes, within S, page
You should have-
36.
Then you should have approached the court that they are not appointing me despite that recommendation or.
No, page 36, Lordship, for a moment, kindly see.
Page,
36. See, here are three names. Number one is my name,
6.
and Lordship would see it was selected on 4/10/21. 4/10/21, at that time I am 64 years.
Yeah, that's right. But on 4/10/21, when they have already selected you
Yes,
and they have not this appointed you, then you should have approached the court, sir. At that time.
at that time I am 64 years, but they
So you
did
should
not.
have-
Well,
Should have approached the court that the 60, I'm going to complete 65 years, 64 years, this 65 years of age, and they are not issuing appointment order despite this, my selection. Then the court would have granted you.
my lord, that was forwarded because after selection by the local people, that was forwarded to the authority.
When?
That lordship kindly see verse 37.
37.
Yes, 37, it was forwarded, but it was forwarded, they approve it much later. Now, my submission is this,
Once your name was forwarded
yes,
for appointment as a president.
Yes.
And if the government is not issuing or the authority concerned is not issuing the order for your appointment, you should have approached at that time before this court.
but not actually, as they were assuring that, yes, your post should be approved,
But
because
after 65 year, completion of 65
No.
years, obviously this appointment itself is not in accordance with law.
Lordship may kindly consider this aspect. It is settled position of law that for the mistake committed by one person, another cannot be
Ultimately, we cannot rule
cause
against the
loss.
law.
So they have delayed the matter. So they cannot take the benefit of their own delay. That is the settled position of law, my lord. So that's why, my lord, for the timing, lordship may kindly issue notice and tell that the order be stayed, and we will hear, we will argue the matter at length.
Not on the date of the file. Precedent date. So once it happens, that's very it's- Okay, 65 भी ज्यादा हो गया, president नहीं बचा।
And moreover, this order is passed without hearing me.
ये भी बड़ा ये बड़ा हाँ, करे, इसको 60 date of appointment, you go like this, your president is specific.
Admit, no need to issue notices, parties are already represented. Risk for hearing in due course.
Mr.
There is-
Tarunia, your,
Yes,
this clause appears to be very, very deceptive. In page 31 of the writ appeal,
yes, madam.
notification dated 27 June 2016.
President and Vice President of the SMDC should not be more than 65 years of age.
On which date?
That is not.
In which date?
Obviously, madam, it is on the date of appointment.
65 years of age, there has to be a cutoff date. 65 years of age when?
Yes.
When he is a graduate or when he retires or when he is selected or when he assumes office? What kind of a government notification is this?
That is not,
You must
clearly
mention it
mentioned.
to your officers.
yes, madam.
These are very
I-
casual
I will convey it, madam.
and unnecessarily these are generating
If
litigations.
any person even selected at 65 years old, they cannot continue as a president on completion of 65 years of age. There must be some provision that
Yes,
on
madam.
the vacancy would arise on account of completion of
Completion of
65
age.
years, so that would be filled in this process. There is no such process.
I'll convey it, madam.
Okay, fine.
Oblige, lordship.
My lord, interim, I have not heard.
Way back in the year 2023, will here consider.
of lordship.
Item 6 to 9.
Me please, your lordship. My lord, this issue in these three writ appeals are as to whether, my lord,
Without following the procedure.
my lord, may I implore that your lordship will take up item number 8, my lord.
Just,
Losing battle. Fighting a losing battle. I am fighting a losing battle. Yes. Yes. Like that. More complicated shareholder. Without following any control. So, you know, the ground. 7 years, 21. Huh? So, then required to make doctrine of useless format. Okay, our packet is the can. That is what I have. Yeah, Harrier development. Meanwhile, more how much is the full bench judgment to get some. Yes, yes, reported only. Harrier development to Vietnam. Harrier development. 17 maybe. 17, no? It's not fully one. Paragraph. Area Dablong, VAB.
Yeah, 2001, 41.
AFDC, let's put it also. Area development, AFDC.
Yes,
Maybe the lordship. May I request that your lordship will take up item number 8, my lord. Item number 8,
8.
my lord. Now, issue before lordship is, my lord, whether the fishery can be settled by the AFDC by PPP mode or not. Now, my lord, the order which was challenged before the honorable single judge, that your lordship will find at page 104. Before taking to the, my lord, into judgment, may I take your lordship to page 104? I'll read paragraph 3. From the record, it is also found that the said settlement dated 21/5/2021, while memo number such and such, was awarded in violation of the full bench judgment of the Honorable Guwahati High Court in Haria Damlong versus AFDC. And as such, it is decided to reject the prayer of Sri Sunil Hazarika, holder, to allow him to continue to run the deal, and hence the settlement of the said deal is hereby cancelled. And the right accrued by so-and-so, aquaculture through so-and-so is hereby cancelled, withdrawn, and the role of so-and-so is also hereby terminated. Now, my lord, the factual question is that in 2017, the settlement was given by PPP mode. And on satisfactory completion of this term, in 2021, it was renewed for a period of 7 years. Now, my lord, this order was challenged before the honorable single judge, and the honorable single judge, my lord, by the interim judgment, which your lordship finds at, my lord, page 148, dismissed, my lord, as many as 23 writ petitions on the same grounds. And, my lord, there are 3 writables now before your lordship. Now, finding with the honorable single judge, your lordship will find at, my lord, page 170.
Paragraph.
Paragraph number is, my lord, 51. I'll read only 2 paragraphs, my lord, 51 and 58.
You're referring to REIT appeal 349.
My lord, readable 314. Yes. The judgment starts at 148. The relevant, my lord, paragraph I'm reading, your lordship will find at page 170. Paragraph 51. In paragraph 50, my lord, at page 169, the Haria Dablong means, my lord, the ratio that has been, my lord, quoted. May I read that, my lord? Instead of reading the judgment.
Yes.
The Assam Fishery Development Corporation Limited is especially incorporated to look into the aspect of the fishery business in the state. The role and functions of the FDC were subject to matter of the dispute, which were finally decided by a full bench of this court in Messrs. Haria Dablong. In paragraph 31 of the said judgment, the following has been laid down. In view of our foregoing discussions, we answer the questions raised as follows. Number 1, Assam Fisheries Development Corporation has the sole authority and jurisdiction to lease out, settle the fisheries which have been transferred or vested with them under Rule 8C 11 of the Assam Fishery Rules. Number 2, this is important.
the AFDC shall have no power to make any direct settlement as per the proviso to Rule 12 of the Assam Fishery Rules. The director of the AFDC shall have the authority to make settlement, and for that purpose, the definite guidelines may be laid down so that there is transparency in the matter of settlement. The need for transparency need not be re-emphasized in view of the canon of decisions of the Honorable Supreme Court. While number 3, while laying down the guidelines or resolution, the spirit of the fishery rules may be given due weightage consideration. Fishery rules were enacted to provide stimulus to fish production and help the population which is engaged with the occupation of fishing. Under the fishery rules, preference is given to cooperative societies formed by 100% fishermen belonging to scheduled caste community and Maimal community of Kachar. Hence, AFDC is directed to lay down the definite guidelines in the matter so that there is no ambiguity. Then page 170, your lordship may skip 5. During the course of the hearing, the copies of the resolution adopted by the AFDC in its meeting dated so-and-so were produced before us, and the said resolution provides that the settlement is to be made for a period ranging from 5 to 10 years, and it should be by way of tender only, and that too to the highest bidder. Now, my lord, coming back to my lord, finding of the full bench, paragraph 2, your lordship will kindly note that AFDC shall have no power to make any direct settlement. Now, the question, my lord, that my lord, submit before your lordship is whether the PPP mode, which has been, my lord, conceived by the AFDC for development of fisheries and the, my lord, fishing community, whether that is a, my lord, my lord, direct settlement.
That is the direct settlement or not?
My submission is that, my lord, that a scheme has been prepared specifically by the, my lord, AFDC, which is a PP mode. That scheme also, my lord, I have annexed. That is my first submission. Second submission is that, my lord, this Haria Damlong judgment is of, my lord, 2011. Sorry, 2001. 2001. And when this PPP mode scheme was prepared by the, my lord, AFDC, they were at least, my lord, supposed to know that this full bench decision is there. And the full bench judgment also directed them to prepare a scheme, which is yet to be prepared till date. Now, my lord, after the 2001 judgment, they had given the settlement in 2017. If we call it a my lord, PPP mode is a settlement, then, my lord, that was given in 2017. And we have performed, my lord, satisfactorily, made, my lord, huge investments. And thereafter, on satisfactory completion of the, my lord, term, it was extended and fresh settlement was given for a period of 7 years. So, my lord, this all happened when, my lord, the full bench judgment was in force, and they were aware of this judgment. Now, all of a sudden, my lord, the person in the helm of affairs, my lord, he changed it and
They are aware of the judgment and they should have followed it.
yes.
So if they have not followed, then what's wrong with the learned single?
All of a sudden they come because, my lord, first thing is, my lord, PPP scheme was prepared by them. It is not my preparation, my lord.
That's right. But once if they have prepared a scheme in violation of the directions or the law settled by the full court, then how you can?
Now, my lord, my submission before your lordship is that, my lord, Haria Dablong, my lord, there are certain directions, assuming that, my lord, that clearly states that it cannot be given even under PPP mode. Assuming, my lord, even then, my lord, we had a contract with the AFDC, an agreement was signed, and that was a concluded contract. Therefore, the Honorable Single Judge, at least, my lord,
Yes.
so that was a concluded contract, and therefore, my lord, the contract could not have been rescinded in the manner it has been done. Because, my lord, it's not a fact. It is not that, my lord, I have not done anything. I have made huge investments there. This was also raised before the Honorable Single Judge. My lord, if your lordship kindly looks at the provision of the Contract Act, my lord, section 72.
Yes.
If I may, my lord, take your lordship to section 72 of the Contract Act, my lord, that's a concluded contract, and, my lord, that could not have been, my lord, rescinded in the manner it has been done. Now, assuming, my lord, the PPP mode settlement was given, my lord, by mistake. And subsequently, my lord, one managing director comes that,
Not by mistake, illegally, in violation of the constitutional norms. Because what was the basis for selecting you?
my selection was under that scheme, my lord.
That's right, but on what basis? What procedure was followed? Just pick and choose.
My lord, in fact, offers were invited. Offers were invited, my lord. If your lordship kindly sees, my lord, section 72, liability of person to whom money is paid or things delivered by mistake or under coercion.
That is not the case. It's not the case.
My lord, when, my lord, in 2001, my lord, the judgment was there and they have given it, my lord, in
That
2017.
judgment still holds the field.
My lord,
That judgment still holds the field.
it does, my lord, it does. It does, but my lord, by mistake, they may have.
That, ignoring that judgment, if anything is done, that can't be rectified or that can't be undone.
No, rectification means, my lord, there is a mistake.
Use that word, rectification, the proper word is undone. That's all.
No, my lord, the use of the word is very important, my lord. PPP mode is not a
Many
direct
events,
settlement that way, my
many
lord. The full bench says that there should not be a direct settlement. It's a PPP mode. And in fact, my lord, your lordship may also have a look at, my lord, section 27 of the, my lord, specific relief act. All said and done, my lord, they had given me this settlement. I have made huge investments to the, my lord, team of more than 40 lakhs rupees. What happens to that?
Only remedy for your client, if at all, will be damages and compensation.
My lord, that may be there, my lord.
Nothing else.
Now, my lord, may I draw your receipt to section 27 of the, my lord, specific relief act for a moment, ma'am. May I read it, ma'am?
Yes.
When rescission may be adjudged or refused, any person interested in contract may sue to have it rescinded, and such rescission may be adjudged by the court in any of the following cases, namely, where the contract is voidable or terminable by the plaintiff. That means, my lord, it is not terminable by me, my lord, therefore, it could not have been rescinded. Where the contract is unlawful for cause not apparent on its face and the defendant is more to blame than the plaintiff. Notwithstanding anything contained in subsection 1, the court may refuse to rescind the contract where the plaintiff has expressly or impliedly ratified the contract, where owing to the change of circumstances which has taken place since the making of the contract, not being due to any act of the defendant himself, the parties cannot be substantially resorted to the position in which they stood when the contract was made. So, my lord, I had made huge investments. And this ought to have been in consideration, my lord. At least my term would have been, my lord, allowed to be completed. When the third parties have, during the substance of the contract, acquired rights in good faith without notice and for value. Where only a part of the contract is sought to be rescinded, this is not.
What has happened to those fisheries? Who's running those?
There was a stay order, but in spite of the stay order.
That's not invited tender, and we have settled 40.
Except one.
Fisheries we have
These have been settled by the
settled,
court.
accepting these fisheries.
Except one.
Fishery since 23, January 20, not in operation. They have invited tenders, I was selected as the hands. So only one fishery is still, yes, I think two fisheries. Two fisheries, including this. So item 8 is one of the persons, and what are the other items? Which I represent. Mayor bill I represent, where one of the petitioner. Retail bill 366, who is the appellant? 366.
Yeah.
Item 6.
What has happened to your fishery?
It is run by the respondent, private respondent.
It has been settled.
It has been settled.
Settled to tender.
All other 40 fisheries have been settled,
To tender.
excepting one.
Against that,
Two where stay of.
we have taken action against the officers also. I have inquired yesterday.
And what about IA? IS, this.
I will not be, my lord, relevant now, my lord, because what happened? There was an interim order in this case. My lord, there was an interim order in this case. In spite of that, a settlement was given to private respondent. Then, my lord, we came on contempt, and then, my lord, that was withdrawn. And that is how it's not settled. So my submission will be, my lord, my lord, one sentence only. In the event your lordship finds that, my lord, in view of the full bench decision, this is an illegal, then, my lord, the liberty may be given to the petitioner to approach the, my lord, civil court for damages.
That is always there.
That has to
It
be.
is already there, paragraph 60, it has been discussed. They may go for a civil meaning.
Any is there.
Page 175.
If the petitioners or pursuant to the initiative that use investment development for the said gains being disputed otherwise, the writ court cannot embark upon the same. The question of right which came to be resolved only by the parties are according limit. What else?
My lord, that may be, my lord.
That is
Get
there.
your- Right.
That is there, already there.
Why don't you withdraw it with liberty instead of getting an order of merit?
Let there be order, my lord.
This application, so far as regarding this application is concerned, this,
Implement.
yeah,
Because the main hearing
In this case, no, we filed an application for vacating the interim order. So since your lordship has heard the matter, filed
no, here in this, this Nisar Ahmed,
that is for implementing the private hospital.
what is the question of implementing him?
No, not required now, since the main.
Not required. This, you are for the applicant.
I am for the applicant.
Yeah, concept for the applicant in IA number so and so, like that, IA number 491/2020. Concept for the respondent has submitted that he does not want to press this IA, dismissed as not pressed. And in the other matters, this writ appeal, connected writ appeals, arguments heard, order reserved.
Court cases are found out, where the arbitrarily cannot be settled. Help. I just made a note.
I think yesterday I inquired lordship, regarding all the officers who did these PT mode, they have taken action and his case is also been examined.
Consult to the applicant.
My lord, if your lordship permits, I will just place one judgment, my lord. That your lordship will responsible.
With judgment.
ABL Enterprise. My lord, ABL Enterprise, 2004 3 SCC 553. About the, my lord, jurisdiction, your
You
lordship.
place reliance on the, before the London single judge also in the ordinary stage.
No, my lord, this was not taken.
Okay, now,
দুটা কপি দিয়া
Okay. Already that much.
Time for respondent number 5.
For hearing, item 10 to 11. 10 to 12.
My lord, in these cases, has a history of long hearing. Leading the argument, my lord, at least I argued not less than 20 days on day-to-day basis. And before, I think 4 or 5 consecutive division
Judgment
bench.
was earlier reserved, but
My lord, the problem is, in this case, whichever lordship takes it up is essentially elevated. That is my problem. So, there cannot be any piecemeal argument.
What do you suggest?
My lord, a slot may be given for consecutive. My lord, last occasion for 7 days, your predecessor, Chief Justice, my lord, Honorable Justice Mehta heard it, reserved it.
So I'll,
Advocate General. Then I was asked to submit the written submission. Those were there. Then 2 months thereafter, my lord, he was elevated. I am not blaming his lordship, my lord. It is my
so
mistake.
I also start hearing.
So, my lord, it will require some time, my lord. After all, the virus and constitutionality of a state act is under challenge. My lord, a slot for, my lord, last occasion, I think the last 4 days, from 2 to 4 slot was given for 4 consecutive days. And only silver lining in this side is, UK Nair was assisting initially, my lord, in this case. In fact, my petition was drafted by him. And during the pendency, he became a senior advocate and then he was elevated. That is the only silver lining of this side. Now, my lord, what I propose in the month of June, my lord, lordship may give a slot. Day-to-day hearing will have to be there. My lord, in piecemeal, my lord, lordship will again forget. There will not be a continuity. Maybe in June, my lord. Consecutive, the lordship may, my lord, decide to take it up at 2 o'clock, my lord, for consecutive days. That their lordship will decide.
First of all, we'll fix a date and then
Hello?
we'll decide
Yeah,
to fix the time.
June.
Item number 10, Lord, I am appearing in.
Yeah,
June.
the same cause is there.
14th of June, my lord, he
You
suggested.
challenge the validity of that.
Yes,
act itself,
yes,
no?
with ground
All
are
the
almost
petitions,
enough.
all the
14th, your
petitions.
lordship can fix on,
No, 10, 11,
June.
10th of. I don't have any.
From 10th of June.
This week, my lord.
18th June.
Lordship.
18th.
18th. But it will have to be on my lord consecutive days, my lord. I am afraid. Your lordship will have to bear with that. My bad arguments.
Consecutive date. We'll fix the date on 18th of June and then we'll decide the time and the
Yes.
day-to-day hearing. We'll fix it on that.
Let it start on 18th. Then your lordship will.
Then we'll fix on that.
My lord.
At the request of the parties, this repetition for hearing on 18th of June, 2020.
Apply, lordship.
That's fixed items. That's fixed items.
Item 14.
Wait, please, your lordship. My lord, this is petition. In this case, my lord, your lordship kindly, my lord. See the order dated 12/10/2023, my lord. 12/10.
Order is the 12/10/23.
Yes.
In response to the direction given by the court number court on so and so, an affidavit has been filed on behalf of the state of Assam when it is indicated that two historic sites belonging to the which is so and so, something that so and so is now proposed to be declared as a protected historical site, and step has in this regard under a competition. We hope and trust that the steps shall be taken expedite regarding the protection of other historical site in the state of Assam. Response from ASI, Archaeological Survey of India, is still awaited. The Medhilanat Council, Central Government Council shall complete this instruction and file requisite affidavit by the next date file listing. Dr. Jogendranath Thukon, who has been allowed to intervene this proceeding, submitted this preparing the booklet incorporating all the historic site of Assam, which are still not covered under the protected monument. We appreciate the effort of Dr. Thukon. After preparing the booklet, Dr. Jogendranath Thukon copy of therefore provided to Mr. D. Saikia, General Lana's Advocate General Assam, Mr. S.K. Medhilana, Central Government Advocate, also to take necessary instruction whether those sites are to be brought under the preview of the protected historical site of the monument listed. So in pursuance to that letter, my lord, no affidavit and no instruction has been placed before the Honorable Book Court till today. आपने तो फाइल कौन है?
So no booklet is filed or what?
My lord, no, booklet is by the intervener.
Yeah.
That is mean, my lord, examined by the state of Assam and as well as central government. But they have to take place instruction and affidavit before the Honorable Court. Nothing has been done till today.
Yes.
Lordship, and for the state of Assam, Lordship, you already filed the affidavit about the monolith of Silpota, Lordship. And regarding the booklet, Lordship, we have served a copy to the department, Lordship. Lordship, sometime may be granted because a detailed report has to be given by the state of Assam. Lordship, the union has to file affidavit as of now.
When this booklet was supplied to you?
Lordship, on 12th of December, Lordship. 12th of Lordship. October, Lordship. But Lordship, it's a detailed one, Lordship. And we've already taken steps regarding the previous issue. And regarding this issue, Lordship, we've already communicated with the department, Lordship. Lordship, all the monuments of Ahom dynasty are to be considered, Lordship. So it's a detailed one, Lordship. Lordship, sometime may be granted, Lordship.
Once you're appearing for the, you're appearing for
For the state of Assam, our Barwa,
from
Lordship.
the state of Assam, submitted that the intervener, Dr. Jogendranath Thukon, has submitted the, has already supplied the booklet incorporating all historical sites of Assam, which all historical sites and monuments of the Ahom dynasty in the state of Assam, which are not covered under the protected monuments, is submitted that the state is considering the said book, the state is in process of examine the booklet, and thereafter necessary orders and directions would be issued, and for that some time may be granted. Stop. Few of the submissions, above submissions made on behalf of the state of Assam. We deem it appropriate to grant some time to the state to look into the state to go through the booklet submitted by Dr. Jogendranath Kankan in Pumela and to inform this court about the steps taken by the state government in that regard, this after 8 weeks.
Mile.
GPR.
Item 15,
May it please your lordship. My lord, the issue that falls for consideration with your lordship in this appeal is whether, my lord, the UGC regulations are mandatory in nature and binding on the state government and the state universities. Now, my lord, may I first take your lordship to the office memorandum which was challenged before the honorable single judge. That your lordship finds at page 79. By this office memorandum at page 79, the guidelines for selection of assistant professors and librarians that was, my lord, issued. May I read it, my lord? Page 79. In partial modification of government OM number such and such dated 25/11/2020 issued by the Higher Education Department, the government of Assam in the Higher Education Department is pleased to notify the following guidelines for selection of assistant professors librarians in provincialized colleges and government model colleges of Assam. Now, eligibility qualification, your lordship will kindly notice the first sentence. Qualification for direct recruitment of assistant professors, reference clause number such and such of the UGC regulation 30th June 2010. So, my lord, by this notification, the qualification as prescribed in, my lord, 2010 regulation of the UGC that has been followed, but the grievance of the petitioner was that before the honorable single judge that the marking system was not adopted.
Marking system was
The marking which has been, my lord, prescribed by the UGC, it is in, my lord, my lord, deviation with the, my lord, this notification. I mean, my lord, this notification does not, my lord, follow the marking patterns. That was the primary grievance because of the fact, my lord, that has been discussed by the honorable single judge also. These persons, my lord, these 6 petitioners who approached the honorable single judge, they passed some 10, 15, 12 years back. And your lordship knows, my lord, every year the marks, my lord, they get more. I mean, my lord, the marks that has been, my lord, allotted to the students that are increasing every day, my lord. As a result, my lord, on the basis of the marks, the persons who passed out earlier, my lord, they cannot really compete. That has been, my lord, agreed to by the honorable single judge. But then, my lord, this marking pattern, there was one difficulty because earlier, my lord, it was percentage system. And now there is a grade point system and there has to be conversion. As a result, my lord, if the UGC guidelines are not followed, these petitioners will never get any job. Therefore, my lord, they had challenged this. And the finding of the honorable single judge, my lord, the impugned judgment starts at page 173, 177. The lordship may come to page 190, paragraph 27. May I read it, my lord? Page 190, paragraph 27. In the instant case, it is stated by the Higher Education Department of the Government of Assam that for the colleges under the department, the maintenance of expenditure is not made by the UGC, but it is made by the state government from its own fund, except maybe for certain occasional grants that may be provided by the UGC for further development of the colleges. In spite of such grants being received, the core maintenance of the colleges are from the funds of the state government itself. Accordingly, referring to the provisions of paragraph 62.3 of the provisions of the Supreme Court in Kalyani Mathivahan, it is the stand of the government of Assam in the higher education department that the provisions of the UGC regulation 2010 in its entirety are not mandatorily applicable for the purpose of colleges under the government of Assam in the higher education department. And on the other hand, such provisions are directory for the authorities. It is the stand of Mr. K. Gogoi, Learned Standing Counsel for the Higher Education Department, that in exercise of its discretionary power, the provisions of clauses 3.00, 4.004, so and so of the UGC regulation 2010 and the prescribed norms for the posts provided therein have been adopted, and in doing so, the provisions other than the aforesaid provisions have not been adopted. My lord, this is incorrect, my lord. I'll show from their own document. By accepting the statement that the government of Assam is meeting the maintenance expenditure of the colleges from its own funds, except for the occasional grants of development for the purpose that may be provided, we are inclined to accept the contention of the Higher Education Department of the Government of Assam that the provisions of the UGC Regulation 2010 are not applicable to the colleges under Higher Education Department in its entirety, except for the specific provisions thereof that has been adopted as indicated above. Then your lordship may come to paragraph 31 at page 193. May I read it, madam? But however, we take note of another aspect of the matter, that the real concern of the petitioners are that some of them have acquired their qualifications about 10 to 15 years back and have demonstrated certain materials on record to show that the strictness of the marks in qualifying examination that prevailed about 10 to 15 years back was much more stricter than what was in the later years. In view of the differences in the marking methods that prevail, the petitioners claim that they have formed a class within a reasonable classification from all such other candidates who acquired their qualification at a later period. In view of such variation, if 72% weightage is to be given to the marks obtained in the qualifying examination and other research papers, the candidates who have acquired their qualifications in the later years, even without their PhD and MPhil degree, in comparison, will be awarded more marks in the selection than those candidates who acquired their qualification about 10 to 15 years back, even when the marks obtained by the such candidates in respect of the PhD and MPhil are also included. Such material itself is an indication that the strictness in evaluation of the examination that took place in the earlier period than that of the later period are at a variance with each other. If a uniform standard of evaluation is adopted, that is weightage of 72% is given for academic performance and other research papers, the candidates who had their qualifications at the earlier period of time would definitely be at a more advantageous position than the candidates who had acquired their qualification at a later period of time. The marks given in an examination are numerical quantification of a performance. If the numerical evaluation over two different periods of time are made by following a different standard, such numerical evaluation across the board may not indicate the true merit of evaluation of the person concerned. In other words, a person securing numerically lower marks in an earlier examination cannot be said to be of lower merit than the candidates who secured numerically higher marks in the later examination. And eventually, my lord, in paragraph 33, the Honorable Single Judge directed that there should be some rationalization. I am not, my lord, challenging that part of the judgment. My submission before your lordship is that I'll try to satisfy your lordship that UGC regulations are mandatory in nature. And I'll, my lord, rely on 2-3 judgments of the Honorable Supreme Court. And the question here is, my lord, whether 2010 or 2000, my lord, the subsequent UGC regulations are of 2018. whether these are adopted by the state government or not. Now the state government has filed an affidavit saying that we have not adopted 2018 regulations, but they are silent on 2010 regulation. And I'll show, my lord, from the documents on record and my lord, from the law, but from the rules, that my lord, 2010 regulations were adopted. And in any case, my lord, the 2018 regulation also says that it has to be adopted by, my lord, all the universities. That also, universities and colleges. Now, my lord, may I take your lordship to page 57? This is a notification of 13/12/2011. And your lordship has already perhaps noted that, my lord, 2010 regulation is of June 2010. So this is subsequent to 2010 regulation. This is a fresh guidelines for marking for selection of assistant professor librarian as per UGC guidelines 2010.
Yes.
So, my lord, this was in terms of the 2010 regulation. And my lord, we didn't have any problem with this. So far as the petitions are concerned, my lord, they didn't have any, my lord, problem. And if your lordship kindly takes up the, my lord, Assam College Employees Provincialization Rules 2010.
Is there a stay of the judgment of learned single judge?
No, ma'am.
No. Any promotion has happened in between?
My lord, there have been many promotions.
900 persons were appointed, Lordship. 950 persons were appointed under the law and law.
And if none of the petitioners were considered.
No,
Why?
they are not qualified. Lord.
Wherever, my lord, they have applied, the, my lord, could not succeed because of the, my lord, lesser number of.
In the writ petition, writ appeal, Lordship, they are, writ appeal, the writ appellants are not considered. Otherwise, in the single bench, Lordship, they have preferred 3 writ petition, Lordship. Out of 3, 2 persons were, Lordship, in the list, Lordship. They were got the job.
Now, what happened, my lord, about the rate petition, my learned friend is saying about. বিভিন্ন পাচ্ছেন এটালে কোনো বনে যেহে পাইছা যে পাইছে চাকৰি পোৱা নাই আপোনালোকে is 60. Then, my lord, there is another office memorandum at page 67.
Just a minute.
I'm sorry. No, you take it, you can go.
First of all, you just satisfy us
I'll-
that even if the UGC has not funded the whatever the colleges and all, then they, even though the UGC regulations are binding upon.
Hmm.
First of all, you show.
That
Because
the,
the learned single judge has non-suited you on this ground and
Yeah.
accepted the state of Assam. That since these colleges are not fully funded by the UGC, therefore these UGC regulations are not mandatorily applied
Yes.
to them.
Yes.
They are direct
yes, my lord.
to satisfy. us
Now, my
on
lord,
that.
what I was trying to show, my lord, one office memorandum I have shown, my lord, they had followed the UGC, my lord, the regulation, the guidelines in toto. There was another notification at page 67 in 2015. There also, my lord, the UGC regulations have been followed in toto. That is at page 67.
Whether it is binding or not, now their stand is this, it is not necessary for them to adhere to the UGC regulations in case the funding is not there by the 100% funding is not by the UGC.
Yes,
This is that case.
yes, my lord.
Yes.
Now, my lord, my submission will be the funding has, my lord, no relation with the binding nature or otherwise of the UGC regulation.
The learned single judge has relied upon this judgment of the Honorable Supreme Court. Where is that judgment?
My lord, I am coming to that. Before that, your lordship will kindly see the rules, my lord, to show that, my lord, the 2010 regulations have been adopted.
Yes.
That your lordship will find, my lord, in Assam College Employees Provincial Rules 2010, Rule 7. My lord, there is that particular rule will be at 498. It starts at, my lord, page 496, relevant 498.
Rule 7,
Rule 7,
direct recruitment.
direct recruitment. Now, Rule 7C. The selection committee may hold such tests of interview for all posts as may be considered necessary. For posts for which UGC has prescribed norms, no candidate should be recruited without having the requisite norms. So that is reflected in the rules itself, my lord.
What is the challenge in the writ petition basically?
Challenge the represent that particular office memorandum, which my lord, my lord accepts the part regarding my lord, the eligibility conditions, but my lord does not, my lord, follow the marking pattern.
No, but have your clients been considered for promotion?
My lord, this is not a case of promotion, direct recruitment. Direct
Direct
recruitment. Now, my lord, the government has filed an affidavit, and in the affidavit, my lord, they have said that 2018 regulations have not been adopted, but they're silent on 2010 regulations.
Confusion हो रहा है यहाँ पे.
And in the affidavit that has been filed by the my lord UGC, they have said, my lord, these regulations are
Have you
mandatory.
annexed the copy of the writ petition?
Yes, my lord.
Page?
The writ petition starts at, my lord, is page 24, my lord. It starts at.
Was there some advertisement?
Lordship, is it
Advertisement is dated?
advertisement, Lordship, yes, various advertisement is issued, Lordship. Altogether, Lordship, 1,050 posts are advertised, Lordship, in various colleges, Lordship.
Hmm.
And out of that, Lordship, already 1,023 candidates were appointed, Lordship.
Now, the procedure for appointment is that every college, my lord, issues the advertisement. So it is not a, my lord, common advertisement. Wherever there is any vacancy in a particular college, my lord, the college authorities take the permission from the Director of Higher Education. Thereafter, they issue the advertisement in local newspapers, and my lord, the selection goes on college wise. Therefore, my lord, we have not challenged any particular, my lord, advertisement. Because, my lord, advertisement keeps on coming at different point of time.
And your clients have applied
They have applied.
In some posts, my lord, they have applied.
and they were not selected.
They have not selected
They applied, Lordship, appeared also, Lordship, not.
because of the marks, my lord.
They have appeared before the
Lordship,
filing of
they
the
appeared-
petition or after?
Before and after.
They participated.
And by this time, my lord, they will also lose their upper age limit. And in fact, my lord, if your lordship permits, my lord, I can show how the, my lord, even the persons who have passed recently, my lord, how they get, my lord, age over the, my lord, earlier persons. If your lordship permits, my lord, I can give a statement I have prepared, my lord. They'll never be selected.
So basically, you have challenged the guidelines.
Yes, my lord.
In the writ petition, this 24/1/2022
Yes, my lord.
issued by the Secretary Government and why a writ of mandate should not be issued directing the respondent, particularly so and so, not to allow college to issue fresh advertisement and further not to complete the selection without properly maintaining the UGC regulation, as well as the judgment surrendered to Honorable Court as per the.
Initially, there was a stay, my lord, subsequent.
Martin. is not supported.
यहाँ पे FAW करो, इनसे तुम तो बेहतर है, तो कैसा है देखो ना।
Kalyani,
Madam.
the Kalyani's judgment is there.
Yes, my lord. Kalyani Mathivahan, that is my lord 2015 6 SCC. My lord, I have given a list of books, a copy of Senegadi. That is my lord 2015, volume 6 SCC. Yeah. Page 363.
कॉपी का मिला ना इधर। और एक दो।
The relevant paragraph, my lord, in Kalyani Mathivahan will be my lord paragraph 62. Last but one paragraph.
So 2010 guidelines have been replaced by 2018 guidelines.
Yes, my lord.
Those are now adopted.
No, my lord, they said that they have not adopted 2018 in their affidavit. They say we have not adopted 2018, but they do not say anything about 2010. In the affidavit, my lord, they have skipped that. They are silent on that.
Mr. Gogoi, have we adopted 2010?
No, till today we have not adopted lordship.
In
We
fact,
have
my
not
lord,
adopted. Even lordship, that particular 2010 regulation was also lordship, honorable division bench or high court held lordship. In single bench lordship, it was in the BC's appointment case, honorable single bench held that lordship. State has not adopted the 2010 regulation. Against that lordship, the division matter preferred before the honorable division bench upheld the single bench order.
Where is that order?
now, my lord, the submission, oral submission made during hearing was that, my lord, a particular clauses of the 2010 agreement were my lord, adopted and others were not. That was the submission on the basis of which my lord, the honorable single judge has come to a finding. But no document has been produced by them to show that part of 2010 has been adopted. In the affidavit, they do not say anything about 2010 regulation at all. It's only oral submission. They say that we have adopted certain clauses and have not adopted certain clauses.
So, Mr. Chaudhary, please consider this.
Right.
If they have adopted, the question would only arise then only whether it could be partly adopted or not. But if the state has not at all adopted, then as per 62.4 of Kalyani, this judgment 2015 6 SCC, the read court cannot compel them to adopt it.
No, my lord, the question is whether it is binding or not, my lord.
It is
There are
not
two-
binding. That's what 62.4 says.
Yes, there are two aspects, my lord. One is, my lord, whether they have adopted or not. In the affidavit, they do not say anything about 2010 regulation. In oral submission, they say part has been adopted. No document has been.
Mr. Whether the state has adopted the 2010 regulations?
No, Lordship, no.
You have said this thing in your affidavit, that
Lordship,
you have not adopted 2010 regulations.
Lordship, that part, Lordship, regarding 2010, Lordship, we have not explained. Otherwise, Lordship, it was decided by the Honorable, our High Court, Lordship. That's why we placed the judgment before the Honorable Single Bench, Lordship. And they have
Why you
annexed.
have not said in your affidavit that you have not adopted this?
Then,
2010?
Lordship, I can file a short affidavit also, Lordship. I can file short affidavit also. Lordship.
In this judgment, where is the learned single judge has said? In which manner?
Lordship, paragraph, in that particular judgment, Lordship, paragraph 26 onwards, Lordship, there is a findings, Lordship. And division bench judgment also there, Lordship, in that particular judgment, Lordship.
Paragraph 27, my lord, it has been recorded, their submission. In paragraph 27, that certain clauses have been adopted. Into. Is this it? Relation.
There are division bench, division bench photo give.
To place policy and intention. It is division by judgment of the place. Will not take to this single day. 39, para 39 में पूरा. Not good.
This, upheld by the division bench.
Lordship. There are division bench something like that. Division bench. One like that. My lord, may kindly peruse paragraph 15. This was our submission before the Honorable Division Bench, Lordship.
He doesn't do it. You know? He hasn't put it. He has moved on to the end.
My lord, paragraph 35 and 34. 34 is the Honorable Division Bench finding, Lordship. Yeah, Osama Shama.
Whether they have adopted it or not. Right?
Yeah. The appellant.
What my learned friend has produced.
Just a. The appellant. Filed this appeal challenging the order passed by single judge dated 21/6/2022. Whereby the learned single judge has held that
We have changed only a part of it, man. Only a part of it, man. This other part rationalization we have not changed. Man.
rationalization
There is a direction to rationalize the mark that we have not changed. Man.
that you have.
Not changed.
Maybe.
One part we have changed.
Yes. What is that? Has held that since the state of Assam, since the colleges and universities constituted under the state law has not been funded by the UGC. The UGC regulations are not required to be mandatorily followed for the purpose of recruitment of various posts in the universities and colleges of the state of Assam. Stop. The state of Assam has took a stand before the learned single judge that they have not adopted the UGC regulations 2010. And therefore also the state is not required to follow the said regulations. It is noticed that in the affidavit in opposition to the writ petition, no specific government, the opposition filed on behalf of the state of Assam. There is no specific government to this fact that the state has not adopted the UGC regulations 2010. Full stop. Learned counsel for the appellant has invited our attention towards certain documents in support of the contention, in documents to impress upon us that the state of Assam has adopted the UGC regulations 2010. The net concept appearing for the state of Assam has categorically submitted that the state that the UGC regulations 2010 has never been adopted. Full stop. The net council appearing for the state of Assam has submitted that a affidavit of this effect categorically stating that the state of Assam has never adopted the UGC regulations 2010 can be filed even at this stage, and for that increase some time. Stop. Time period for is granted. List on. Just after 3 weeks. File a specific affidavit of this respect, then we'll consider.
One judgment my learned friend has submitted, my lord, the division bench. There is a subsequent division and then judgment of our High Court matter. I'd like to please where Honorable Justice Suman Kumar also there with my lord Honorable Justice Sandeep Mehta, where it is said, my lord, it is mandatory.
Mandatory in case here in these judgments.
Yes, I
They have
understand.
specifically said that the Guwahati High Court has, this state of Assam has not adopted the UGC regulations 2010. This is what the finding is.
Let him give you my obliged. Highly obliged.
Item 16.
May I please, all of you? My lordship, this writ appeal, my lordship. Judgment is on page 82, my lordship. My lordship, the fact of the case is that, my lordship, in the year 2013, one advertisement was issued for issuance of dealership of LPG under the scheme which is called Rajiv Gandhi Gramin LPG Vitarok scheme, my lordship. I applied for the particular, that is the Sudarshanpur part 2 and 3 Kalachara grant for that area, my lordship. As per the advertisement, there is a requirement that the concerned, the applicant
will get preference if they are resident of the concerned Panchayat area, my lordship. They were residing in the.
Part of the matter, please come, we'll continue with that. Part of matter. Mr. Laskar, there is a partner matter after that. Item 3 and 4, partner matter.
Item 3 and 4.
I'll see it. Yes, signature.
Yes.
The other day, Lordship, I have finally placed the report conducted
in the month of December, and the whole report I have placed it.
Mr. Saikia and Mr. Chaudhary, you are yet to make your arguments. But here, as my lord has been pointing it out, and we have had a conference, there is only one thing which will be material at this stage. Only one thing. We are not on the question whether the judgment of the single judge is correct or not. We are not on even on the question as to whether the judgment of the division bench is correct or not. Because the review petition of Mr. Saikia said that he is not complaining about the division bench judgment.
Then why the review?
That's the answer we are seeking from you. His argument is that the division bench judgment was premised on the fact that there is already a report by the CID inspector, and therefore, as per para 7.3 of Madhuri Patil, there is no scope for any further inquiry. It has attained finality. But 7.3 has a rider. If the report is found to be truthful and free from defect. So he is saying that subsequent inquiry, which is rebuttable, you are free to rebut, has indicated that the CID inspector has submitted a sham report. He has not conducted any inquiry, and these findings and observations are totally contradictory in the sense the Gaubura himself has said that we don't know this person. Many relevant facts, according to him, are not properly projected or wrongly projected. And there is a criminal proceeding now initiated against, or departmental proceeding initiated against that particular inspector. So his argument is that there is no report of the inspector which is acceptable in the eye of law. In other words, this report now, in view of these findings, do not meet the requirement of 7.3 of Madhuri Patil. If that be the case, his submission is that the writ appeal requires fresh hearing on merit. Now, it is one thing to say that his argument, even if it is accepted, that will only lead to fresh hearing of the writ appeal. And in that case, we'll consider whether the report of the inspector is liable to be discarded. And if so, what is the other recourse available to the state in the matter? And to that extent, whether there is any scope of interference with the single judge's order. That will be the broad scope of inquiry if the review is accepted. If the review is rejected, the matter ends there. So therefore, the only question would be that the materials which now Mr. Saikia is pointing it out, whether those are sufficient for the court to hold.
No, my lord. I would put it other way.
Hmm.
Whether the materials which now state is relying was before the division bench or not. That question should have fallen from this
No, it
honorable
was
court.
not.
These were very much before the division bench. Even before the single judge.
No. So you argue, but
Yes.
that will be the
No,
scope
my
of-
lord. Lordship will be rewriting review jurisdiction. Lordship will not do. This is a case where state is abusing its power and authority. And I will demonstrate it, my lord. It's a case where this review petition should be dismissed by awarding exemplary cost. My lord, they are relying on materials which were before the division bench. Everything were brought before the division bench by the appellant, that anti-corruption body. My lord, when the highest law officer of the state gave the opinion that you should make a re-inquiry, what was the material before the highest law officer of the state? What was the material? Tomorrow material will come, therefore make an inquiry. Can that be a ground of review? Well, this lady has been put to harassment. Her family has been harassed. I'm very sorry to say, my lord. I'm a bit hesitated. I'm sorry to say that. This is a case, my lord, who is the chief minister of the state to order an inquiry in these matters? Has this constitution given him any extraordinary power? My lord, lordship knows that Kane commissioner's case. Now, in the Madhuri Patil judgment, which is a code in itself, is any role envisaged for even an SP rank officer? DSP and inspector of police, that's all, nothing beyond that, my lord. And my lord, kindly see Please come to the review petition for a moment, my lord. I'll just refer to one paragraph from the
It's all right.
DB judgment. No, I'm just,
Let him finish, then you can.
just one paragraph, my lord.
Yes.
Please come to the review petition. Para 14. Lordship is not sitting in appeal over this, my lord. Page 37. No, testing the I'm sorry. Page 38, para 15. Lordship is definitely not sitting in appeal over this. Testing the report of the vigilance officer, the inspector CID on touchstone of the principle laid down in case of Kumari Madhuri Patel. We find that inquiry report submitted by the inspector CID does not indicate even the slightest that the particulars given by the candidate were false or that the social status certificate had been fraudulently obtained. Thus, in terms of the first part of para 13.7 of the guidelines formulated in Kumari Madhuri Patel, which provides, in case the report is in favor of the candidate and found to be genuine and true, no further action need to be taken. Now, I'm sure Lordship is not sitting in appeal over this finding of the learned division bench, my lord. Can you see, my lord? And please come to para 4 of the review petition. How everything, what triggered this one review petition? Please come to para 4. Page 7. That the petitioners respectfully state that pursuant to the Honorable High Court order dated so-and-so, passed in WPC number so-and-so, and subsequent order dated 17/2/23 passed in WPC number so-and-so, the matter relating to service of petitioner is under consideration of higher authorities in the government. The authorities have explored the available legal remedies against the order dated 24/11/22, passed in WPC number so-and-so, and as suggested, the department has sought opinion from the highest law officer of the state as regards the service of the petitioner and the follow-up action to be taken in view of the Honorable Court's order. Now, that means, my lord, when the highest law officer of the state had the occasion to give an opinion, what was the material before the highest law officer to even doubt that certificate, my lord? Oh, tomorrow some material will emerge, therefore this report cannot be accepted. Can that be accepted? Does it not come down to, boils down to that, if we go by the state's case? And my lord, they are relying on that 31 July 23 order. Those three materials, that name was not monsoon, that the earlier Mondal gave, sorry, Gambura denied that he issued the certificates regarding that DC officer. My lord, no, wait. Please come to my lord, page number 118 of the additional affidavit. Yeah, 1182. My lord will kindly come to our affidavit in opposition in the review petition at page 118. Now, this is one of the ground, my lord, that office of the deputy commissioner just registered FIR against me. Now, let us see whether it is correct or not. In fact, on some false statements, my lord, this review has been structured. Page 118. Now, this is a press release issued by Jano Sangjok, my lord, on behalf of the Deputy Commissioner Jorhat. Some unknown person has issued a government letter to Monsoon Borkakoti of Club Road, Jorhat on 26/3/19 by using the name of the Rashni Aparajit Karoti, Deputy Commissioner Jorhat. In this regard, the said Deputy Commissioner has lodged an FIR on 3rd April before the Jorhat police order against such unknown person. However, it has come to the notice of the Deputy Commissioner that since last few days, some newspapers are circulating the news that Deputy Commissioner had lodged an FIR against Monsoon Borkakoti. This is one of the ground for review. The said Deputy Commissioner has neither issued any letter in the name of Monsoon Borkakoti nor lodged any FIR case against her. As informed by the Deputy Commissioner, some unknown person has issued the letter by forging her signature. As such, the Deputy Commissioner has taken the matter seriously and requested the police to take immediate My lord, this part of the information the CID SP could not gather, but he could gather so many other materials. Why, my lord, this press release was not made, not annexed to the state's review petition, my lord, if it is not malafide? There, my lord, having a police force, they are doing everything. Why they could not find out this? Please come to that later, my lord, at the review petition. But this is their ground. 31,706. Please come to page 52 of the review petition.
Just a minute. Just a minute. Which is that certificate of the deputy commissioner, which she says was forged?
Page 52 of the review petition. C. Kindly see the, my lord. Lordship has seen the press release and see the context in which it has been used here. What is the impression that is sought to be given? Monsoon Borkakoti had received a letter dated 26th of March 19 from the Deputy Commissioner Jorhat asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake, for which R.A. Karoti, the then Deputy Commissioner Jorhat, had submitted a written complaint dated to the officer in charge for taking her signature and official seal. Well, tell me, let us try to understand, my lord, how this could be a ground for review. Now, what is being sought to be projected? And see the context in which that letter was issued. Some fake letter was issued.
That's all, Mr. Chaudhary.
Yes.
See, if we find that
So
there are
I'm just-
materials,
These are the broad facts. my
correct,
lord.
correct. There are materials to cast aspersion on the report of CID.
Yes.
Probably the matter will be re-examined.
No, my lord, there is
Otherwise,
nothing.
we'll
No, my
decide.
lord. Yes, now I'll come to that, my lord. There are two ways of looking at it. Question is, my lord, assuming for the sake of argument that there are some materials, is it in the province of review to be corrected?
That's what he's.
And my learned friend is referring to the judgment of BCCI. My lord, that BCCI judgment, if your lordship reads it properly, lordship will find there were some undertaking given to the court, my lord. Those undertakings came to be incorrect, my lord. It was in that context that Honorable Supreme Court said that even for facts which may be emerging later on can be taken note of.
Very
But
well.
that's not
what-
the general rule.
So that is what, please address the court. And
Yes,
then only-
I'll address.
Yes.
Till now, I have not placed any judgments. I have just referred the BCCI case, but in what context and what is the further development of the law relating to review, I'll place it.
Yeah, come on.
Yes, Lordship, I'll come to that.
Yes.
But what exactly happened, Lordship? Page 64 for a moment. Page 64 of the contempt petition.
So, Mr. Saikia, the materials that you are now relying upon,
Absolutely.
were those not available where before the judgment
No.
was delivered?
No, Lordship, no.
These are not part of
No,
records.
no, it's not part of record. The main record which was part, everything come up after June 2023. June 21st June, the delivery of judgment was there regarding the writ appeal. Our exercise, basic exercise started from 14th of June. There is a page 64 for a moment, the contempt petition. Why this in the contempt appeal? Why everything come up? Because when the inquiry was going on in the first round, and when there is a when the matter was pending before the state level scrutiny committee in 2019, on 3rd of October, the inspector submitted the report, which is the basis for all the judgments, the learned single judge as well as by the division bench. At that point of time, another inquiry was conducted by the state government through the Deputy Commissioner Jorhat. The state level inquiry committee considered both the report of the vigilance officer, that is the CID inspector, as well as the Deputy Commissioner's report. That when the government wanted to comply with the learned single judge's order, then one opinion was formed by the government, page 64 of the contempt petition.
Yes.
Or contempt appeal. Serial number 8. That is on 23rd March 2023.
Yes.
The Honorable Chief Minister Assam has instructed to review the matter since finding of the CID and the state level scrutiny committee / Deputy Commissioner Jorhat. So 2 reports, one is the state level inquiry committee as well as the report of the Jorhat are contradictory to the report of the CID. And LR has internally highlighted that the state respondent has not challenged the order of the Guwahati High Court, etc. Thereafter, it was decided that the appeal will be filed. There is no question of review at that point of time. On 19th, the opinion went to the government that immediately file appeal.
Just. Yes. No, we have.
First review to the acceptance.
Yes.
Lordship. So on 23, so therefore Advocate General may be approached by the Personnel and Social Welfare Department to offer his advice for filing of appeal. Then on 19/5, the AG has opined that the judgment dated so and all subsequent orders required to be challenged before a larger bench by filing appeal. So no question of review at that point of time, while explaining the issue of limitations by reasons. On 14/6, the Chief Minister directed the Personnel Department to immediately file writ appeal. There is no question of review, as advised by so and so. 16/6, the instruction came to the AG's office for filing of the review. In the same file, it was also ordered that kindly the CID inspector, CID officer was directed to find out why there is a contra report of the inspector vis-a-vis the report of the deputy commissioner, as well as a state level scrutiny committee. But our course was to file the appeal. When we prepared the appeal and we went to the registry to file the appeal, we have come to know that on 1st of June, the appeal was already disposed of, filed by the third party. The exercise was done. Who was to be blamed for giving that report?
But
Whether-
can you still not file an appeal?
No, we cannot.
Why?
Because the judgment, there is no flaw in the judgment. I'm repeating, Lordship, there is no flaw in the judgment. If we look at the report of the inspector, if it is sent at that point of time, there is no flaw. It has complied with the provisions of Madhuri Patel's, but his inquiry.
Yes.
Lordship will kindly take the review petition, the first part. Review petition, page 8.
Page
8. I'm reading from the third line. Have Lordship got it? May I read it, Lordship?
Yes.
In reply to the same, the highest law officer of the state has expressed his displeasure about the manner in which the caste verification report dated 21/10/2019 was submitted by the CID Assam on the basis of enquiry report dated 3/10/2019, submitted by the inspector of CID, and also pointed out various issues. The law officer of the state has suggested a judgment dated judgment of 2286/2021 and all subsequent orders requires to be challenged before the appellate forum. No reviews here. However, in WA 42/2023 filed by one Anti-Corruption Liberation Union against the judgment dated 24/11/2022 and dismissal of the aforesaid appeal by judgment dated 1/6/2023, the department could not file the appeal and the department was further advised to prepare SLP before the Honorable Supreme Court in that event. So that was our line. The competent authority on 14/6, so this was after the judgment was delivered, has also directed, one direction was to file appeal. The next direction, the competent authority also directed the principal secretary, Home and Political Department and Personnel Department to examine as to whether there was any malafide intent or misconduct on the part of the concerned SP CID and the inspector of CID in reference to the caste verification report submitted by them. Accordingly, the Personnel Department requested the Home and Political Department to make an inquiry in the manner which the caste verification report was submitted by the CID officials. In response to the same, the Joint Secretary to the Government of Assam, Home and Political Department by a letter dated 14/11/2023. So you came up to November now. Furnished a letter dated 7/8/2023 issued by the IGP CID stating inter alia that there was no malafide intent or conduct on the part of the SP CID Assam in connection with the inquiry. However, the inquiry reveals that the Inspector Dibbojyoti Datta, the then inspector, had made a perfunctory inquiry while verifying the caste status of the petitioner, and various vital aspects were not considered by the inquiry officer. The Joint Secretary to the Government of Assam Home and Political Department has also provided a copy of the inquiry report dated 31/7/2023, which was conducted to ascertain as to whether there was any malafide intent or conduct on the part of earlier inquiry officer or not. Suppose the report has came in favor of the inspector, that everything was done properly. There was no issue of either appeal or review. All this happened after judgment 1/6/2023. On 14/6, the CM directed to file appeal, but it was known that appeal has already been dismissed. The second option, the Honorable CM directed that find out why there is a difference of opinion of the inspector's report as well as the report of the Deputy Commissioner and state level scrutiny committee, whether there was any malafide intent was there or not. Finding of the department was that the SPCID had no malafide intent, but the inspector who conducted the report and who conducted the investigation and submitted the report, it was done in a very perfunctory manner. So that is the finding. Thereafter, the government, what they have done, paragraph 5, the petitioner respectfully state that after receipt call till that moment, our intention was to file SLP or LPL. But at that point of time, it was not known that whether there was some flaw or not. But once the flaw have come to light, then what was our situation? Paragraph 5.
Just a minute. Yes.
That 14 sheets later, Lordship will find at page 49, annexure 4. From the Joint Secretary to the Home and Political Department, wrote to the Secretary to the Government of Assam Personnel Department. With reference, there's a reference of letter dated 16/6. Lordship will kindly note that 16/6, on which that the CM's direction was communicated through official communication. Page 49. With reference to the letter on the subject cited above, I am directed to inform you that, as stated by the Office of the Additional Director General of Police CID Assam, by memo dated 7/8/2023, there was no malafide intent or conduct on the part of the SP CID in connection with the inquiry. Necessary enclosures in this regard as furnished by the officer of the ADGP is attached herewith for favor of your necessary action. So the first covering letter says SP was not at fault. Next page, the annexure report, 7/8/2023. the Inspector General of Police wrote to the Additional Secretary, Government of Assam, Home and Political Department. First paragraph. With reference to the, here also reference is 22(6) after the judgment. With reference to the subject cited above, I would like to inform you that an inquiry was conducted into the matter. The inquiry was conducted by Punamjit Nath, APS, Deputy Superintendent of Police. The inquiry revealed that the Inspector Dibbojyoti Datta, the then inspector, had made a perfunctory inquiry. However, it has been ascertained that there was no malafide intent or conduct on the part of the SPCID. So this inquiry, Lordship, was relating to the role of the inspector as well as the CID SP. It was nothing to do with the certificate at that stage. While doing this inquiry, it was found that the inquiry done by the inspector was not correctly done. Then what happened? Page 9, paragraph 5 now. Now we are coming back. The petitioner respectfully states that after receipt of the aforesaid communication dated 14 November 20, which I have just read it, from the Home and Political Department with the inquiry report, etc., the department has again taken up the matter with the highest law officer of the state as regard to the further action to be taken in the matter of subsequent development as stated above, and accordingly the relevant file has been endorsed to him on 28 November. Thereafter, as per advice, the petitioner have preferred this review applicable. Till that moment, our whole stand of the state government was to file appeal, if at all appeal was to be filed. But once we got the letter of 14 November 2023, which divulged that the inquiry was not done correctly or in a perfunctory manner, then we have changed our strategy from appeal to review. Now, what happened thereafter? The petitioner states that because of the aforesaid development, department is facing difficulties in taking a final decision in the matter. Therefore, the compliance of that order was at stake. So now, what the Supreme Court says, whether we can go for a second inquiry or not, the law is very well settled now. 2021. The other side counsel was very annoyed that why we have gone for the second inquiry, whether the chief minister can go for that or not, and what documents were placed before the highest law officer that the second inquiry was required. These were the submissions. My submission to that is very clear. 2021 9 SCC, page 811. 2021 9 SCC volume, page 811. J. Chitra versus District Collector and Chairman, State Level Vigilance Committee, Tamil Nadu. And the 23rd November's letter also contained the investigation report of the inquiry. Paragraph 10, last 3 lines. Paragraph 10, last 3 lines. Reopening of inquiry into caste certificate can be done only in case they are vitiated by fraud or when they are issued without proper inquiry. So it is a permissible exercise in my humble submission. Reopening of inquiry into caste certificate can be only in case they are vitiated by fraud.
Where you reading?
I'm reading paragraph 10, last 3 lines.
Paragraph 10.
Paragraph 10. J. Chitra's case.
Page 817. Yeah.
Reopening of inquiry into caste certificate can be only in case they are vitiated by fraud, or when they are issued without proper enquiry. Here, both the elements are there. May I read the whole? In the instant case, an inquiry is conducted by the district level vigilance committee, which has upheld the community certificate in favor of the appellant. The decision of the district level vigilance committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of appellant by the district vigilance committee has become final. The state level scrutiny committee did not have jurisdiction to reopen the matter and remand for fresh consideration by the district level vigilance committee. The guidelines issued by government order dated 12/9/2007 do not permit the state level scrutiny committee to reopen cases which have become final. The purpose for verification of caste certificates by scrutiny committee is to avoid false and bogus claim. Repeated enquiries of verification of castes would be detrimental to the members of scheduled caste and scheduled tribe. Reopening of enquiry into caste certificate can only be in case they are vitiated by fraud or when they are issued without proper enquiry. So this is the
OBC, right? This is OBC.
this is OBC. The same spirit can be followed in every case, Lordship. Basically reservation, because if Lordship is pleased to look at paragraph 7. 7 says, realizing the pernicious practice of false certificate being utilized for the purpose of securing admission to educational institutions and public employment, depriving genuine candidates for the benefit of the reservation, this court in Madhuri Patti scale, those directions were. So the Honorable Court realized that there is a large scale pernicious practice of getting fake or undeserving certificates to reap benefit for employment or for educational purpose. So in that situation, Madhuri Patil and all these subsequent judgments came up. Had that there been a very utopian society, this
The reservation debate is not sparing anyone in the country, it seems.
absolutely not. The thing is that the genuine candidates should get lordship. That is the ultimate goal of the framers of the constitution. That was the ultimate objective. We people are misutilizing that benefit.
There are more such cases according to you?
Lot of, and why this government is more conscious. The chief minister himself belongs to upper caste. That was the statement he made. If I allow a upper caste person to reap benefit, which a person does not deserve, then the fault will be more now. Same is the case of the other officials. So they have a duty to protect the interests of the actual deserving and the persons who can get benefit of the reservation policy. So now coming further. So in that situation, Lordship, the review was filed. It was not earlier. So we also know what the law relating to, and we have a very limited scope. Now that limited scope, Lordship, I would like to place, before going to place the judgments, 1 or 2 documents I would like to save, place just for cursory look.
Just a minute, just.
Hmm? Not possible, no?
ডিভিশন বেঞ্চ ডিসি অফিসার এনেকে ডিসকার্ড করে চলিয়ে দিয়েছে। এরা কত না ট্যাক্স লাভ করতে পারে।
Yes. Yes.
So before the learned single judge, page 30, paragraph 4, last line, the petitioner side counsel submitted, based on the fact that the girl child was residing with her mother and following the customs and rituals of Koch community, a certificate dated 13/11/2006 was issued in favor of respondent. So this was their case. That she is staying with her mother only. And she is following the custom. The vigilance officer in his report, that is also quoted by the learned single judge, page 22 says, I visited the parental address and present address, Golaghat and Jorhat. In course of inquiry, it is found that the father of the alleged named Dr. Santanu Borthakur, born and brought up at Silpukhuri, Guwahati, followed the original rights of Kolita community and got appointment as medical officer and was posted at Jorhat. The said doctor got married to a lady hailing from Koch community and used to reside at matrimonial house wherein alleged Miss Monsoon Borkakoti got birth at her mother's house. And since then, she had her education at Jorhat and accepted the customs of Koch community. So everything was telling with the submission of the writ petitioner. And finally, the learned single judge fully relied upon the judgment of the report of the CID inspector and allowed the writ petition to set aside the scrutiny level committee's decision. Now coming to the division bench report judgment, paragraph 14 says, in the wake of discussions made herein above and keeping in with the categorical affidavit filed by the state government authorities before the learned single judge, placing on record the report dated 3/10/2019, which was prepared after thorough inquiry conducted by the vigilance officer. So we also relied. It is not that we did not rely. We believe that the report is correct. Inspector of Police CID in the present case under the supervision of SP CID concluded that the allegations regarding falsity of the social status certificate of Monthly was based on no truth. And the only course of action that required to be taken as per the ratio of the judgment of Kumari Madhuri Patel was to accept the said report of the vigilance officer, Inspector of Police CID. For sake of repetition, it may be mentioned herein that the state level scrutiny committee, while passing the impugned order dated 26/2/2021, did not objectively consider the inquiry report of the vigilance officer, that is Inspector of CID, which was mandatory requirement as per the guidelines laid down by the Honorable Supreme Court in the case of Kumari Madhuri Patel. A perusal of the said speaking order would reveal that the scrutiny committee, though referred to the report submitted by the Superintendent of Police CID, but no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that the respondent petitioner was not entitled to the benefit of OBC certificate, the scrutiny committee relied upon a parallel report, that is the Deputy Commissioner's report, which got conducted through the circle officer Jorhat. Apparently, in terms of the judgment of Madhuri Patil, the circle officer has no jurisdiction to carry out such inquiry. But from the point of view, from the Honorable Court's point of view, it is correct position. From when the government is found that one of my agency is finding a report which is favoring the writ petitioner, the other report, the Deputy Commissioner and the state level inquiry committee, they found their finding was totally contrary, opposite pole. Therefore, government wanted to know who is at fault. Either the inquiry committee or the Deputy Commissioner's report is not correct, or the inspector's report is not correct. If the inquiry report of the inquiry inspector was found to be correct, there was no question of filing appeal or filing review application. But it was found that the report submitted by the inspector was not correctly done. Paragraph 13.5 of Madhuri Patil's case not complied at all. He rather went on the Supreme Court judgment. Who should get, who should not get, who should not get, who should not get. Paragraph 15 says, testing the report of the vigilance. So Honorable Court fully relied and based the judgment on the basis of vigilance officer's report. Paragraph 14. The testing the report of the vigilance officer, the inspector, that is the Inspector CID, on the touchstone of the principles laid down in Madhuri Patil, we found that the inquiry submitted by the Inspector CID does not indicate even in the slightest that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. The report was totally in favor and there was no fraudulent report. So Till that moment, Lordship, we also were at dark. What could be the contra report? Because the vigilance officer is the actual competent authority to do the investigation in terms of the Supreme Court's guideline. So when we found that 31st July's letter, page 6, where my learned friend only referred to C, but he did not refer to A and B. He that C regarding the fake letter issued in the name of the Deputy Commissioner Jorhat. What about B? The Gaunpura's opinion. So this inquiry was done to find out who was at fault, whether there is any malafide intent on the part of the CID department while conducting the investigation.
Yes. How long, Mr. Saikia, how long will you? require?
Because I have to place few judgments, Lordship, which are very relevant. Otherwise, I will not consume anything.
And then Mr. Chaudhary will require some time. We'll continue, but today there is a reference.
Yes, Lord.
No, we'll continue and try and see. Let us see and finish.
I will not take much time. Facts I have placed, only laws which will not take much time. So the other day, Lordship, I have placed the first report as well as the subsequent report. And after the subsequent report, we have also placed the central government's notification how caste status of offsprings of separated, divorced and single women are to be given. That also document of 3/10/2019 has been annexed. And finally, after getting this report, we have taken two actions. One action is to start the department suspending the concerned police officer who conducted the inquiry, and also department proceeding was initiated against him. And at the same time, we are again following the Madhuri Patil's direction at page 184, by which we have issued a so-called notice to the, because the findings are with us of 26 December. On 28th December, we issued a so-called notice to Monsoon Borkakoti saying that whereas on receipt of a communication from the Joint Secretary to the Government of Assam Social Justice and Empowerment Department, Dispur, regarding fresh inquiry done by CID Assam on the caste certificate. And whereas Superintendent of Police CID Assam by communication dated 26 December 2023, page 184 of the additional affidavit, has submitted the inquiry report on the status of your caste certificate as doubtful, which was carried out by the inquiry officer Srimati Moromi Das, APS, Additional SP, CID. Whereas in pursuance of the directives of the Honorable Supreme Court, Madhuri Patil versus so-and-so, dated so-and-so, has laid down the procedure of dealing with the matter relating to fake certificates. Therefore, before any action is warranted against you, you are hereby given 2 weeks' time from the date of receipt of this so-called notice to explain reasons why, which led to obtain a caste certificate to which you don't belong. In case no reply is obtained, necessary action as laid down in OM is initiated against you without any further notice. A copy of the inquiry report submitted by the inquiry report is enclosed herewith for your ready reference. So you issued this so-called notice.
That is dated
28th of December 2023. Immediately. That 2 weeks time elapsed, we could have immediately cancelled it. We did not do anything. On 2nd or 3rd February, during the contempt appeal hearing, Lordship was pleased. 8th of February, this honorable court, while hearing the contempt appeal, was pleased to stay the contempt, the impugn order in the contempt appeal, and also verbally said that we should not, because they were saying that we are proceeding against them. One is this so-called notice of 28th December. The other one is that the father obtained a fake certificate of OBC in 2019. That was also found out during the course of investigation by the senior CID official. In her report, she said that the fake certificate was obtained by the father also to mislead the investigation. So a police case was also registered against him. So we are not going ahead any further because there is a direction from this honorable court, although orally, that we should not go ahead till the disposal of these cases. So we are not proceeding any further. In case, if we had cancelled her certificate in December after 2 weeks elapsed, she would not have any certificate at all today. But we are following the due process as laid down by the Honorable Supreme Court, as well as we have a guideline also issued by our government department, which is also a part of the record.
But how could you have cancelled when the division bench judgment is there?
We have not cancelled. We have come. That's why we have come before this honorable court to file review that this is the position. We have found all these things. We are not sitting over appeal over a division bench judgment. So we came. What are the options open to us? Our only option is to file review. We cannot go and challenge it before the Supreme Court also. These facts are not part of the record at any point of time. That the brother is the general candidate in his education. The mother obtained an OBC certificate in 2019. The father, who is a general candidate, is he obtained another certificate in 2019. Everything, the Gaon Bura's withdrawal of his certificate, the fake certificate issued by the another Gaon Bura, all these we have come to know on 26th of December. The review is therefore before this honorable court. Suppose we are not filing this review. We went to the higher court. The first question would have been put to us, as in normally in all other cases, that have you placed all these facts before the court below? That would be the first question. Suppose a new plea is taken in a division bench here in an intra-court appeal. We have not placed those records before the learned single judge. So SLP is not the option to now. We have the single option now, that is review, because we have to bring all these facts before this honorable court. And what is, suppose the second inquiry also disclosed that her certificate is genuine. What the government had taken, CMO opinion to get. CMO here, page. In the contempt appeal, if Lordship is placed to take page 16.
Sixteen,
1660. This is a note of the Chief Minister to the Chief Secretary. Page 60. Of 17 December. It appears that the authenticity of the OBC status of Srimati Monsoon Borkakoti is in serious doubt. While I fully respect the majesty of the Honorable High Court and I am committed to complying with the direction of the Honorable High Court, history will not forgive me if she is reinstated in service without final verification of her OBC status. In this backdrop, a prayer may be made before the Honorable High Court to grant state only 15 days time to take a decision on either implementation of the order of the Honorable High Court or to file a review petition in the Honorable High Court or Supreme Court with the bona fide intention of upholding the fair play and justice to all concerned. Further, so and so, that second part is not very important. So when the investigation was going on, this was before 26th of December, about 9 days earlier. The government decided that we are going to comply if the report comes in her favor. It has gone against them with all these overwhelming facts that the parents are living together, they are happily married. There is no situation that the father is depriving her daughter from all the benefits, educationally, socially, economically. What are the parameters to get that certificate? That Lordship, I have already placed the other day. That's in case of single parent, 181 of the additional affidavit. In the additional affidavit in the review petition at page 181, caste status of offspring of separated, divorced and single women. According to the single officer lordship, the CID inspector in his first report, she has adopted her mother's caste and she is staying with her mother. In that situation, this may be applicable if she is living as a single woman or she is a divorced or separated woman. But that is not the case. All these important facts were never considered and never unearthed. If we look at paragraph 5 of Madhuri Patil's case, it is very clear. That is quoted in the judgment also, and here is Madhuri Patil. Paragraph 13.5 says, each directorate should constitute a vigilance cell consisting of senior DSP in overall charge and a number of police inspectors to investigate into the social status claims. The inspector would go to the local police of residence and original place from where the candidate hails and usually resides, or in case of migration to the town or city, the place from which he originally hailed from. The vigilance officers would personally verify and collect all the facts on the social status claimed by the candidate or the parent or the guardian, as the case may be. He should also examine the school records, birth registration, if any. He should also examine the parents, guardians, or candidates in relation to their caste, etc., or such other person who have knowledge of the social status of the candidate and submit a report to the director with all particulars as envisaged in the proforma, in particular of the scheduled tribe relating to their peculiar anthropological, ethnological traits, deity, rituals, customs, mode of marriage, death certificate, method of burial of dead bodies, etc., by the caste or tribe or tribunal committee, as the case may be. So, when all these facts were unearthed by the subsequent inquiry report of 26th December, we issued the so-called notice to her. Till now, it is neither challenged nor responded. That information I have not, but my friend is saying that they have responded it with. And the second inquiry is more startling findings. Lordship will find at page page 131 paragraph. Srimati Monsoon Borkakoti recited. I'm sorry.
Now. Thank you. Any other subject? Let's see, if it's any other subject. Order 47 to 1. Diploma. Is there anything on the subject matter? Something more. We're not taking. That is the. Do something against it. And then. Huh? Huh? This is what they want. Tell you what they are.
Mr. Saikia, this matter has very tricky angles. We are trying to figure out.
But when I will place the law,
You will place the law, definitely, and we'll consider. But the one question is troubling, and maybe you have a good answer. If the review is allowed, the writ appeal will have to be heard on merit. In the writ appeal, you will ask for liberty to hold an inquiry about the caste certificate, validity of the caste certificate of the private respondent. That's the liberty you will ask
no,
ultimately.
because that process has already gone and they have not challenged it,
That's
they
what
have
that's
accepted it also.
That's the query.
Yes.
If the writ appeal is finally reopened and heard on merit, then you will, from the state, you will say that allow us to conduct and go ahead with the inquiry
Complete the inquiry.
and complete it. That's the final relief you will seek as a state, is it not? If you file an appeal. You have not filed an appeal, but assuming you file an appeal, that's the relief you are going to ask for. Now, after the division bench judgment, which has affirmed the single judge's judgment and found that her caste certificate issue is brought to a closure, would the state have on his own started another inquiry without the leave of the court? Government. See, the division bench has already gone into the matter and held that this judgment of the single judge is valid and the caste certificate issue stands resolved finally. You have come before the review court saying that some materials we found later on and this matter calls for reconsideration. Very fair. But before all these things were done, you have already started an inquiry against the petitioner.
Absolutely.
And that is against the order of the division bench.
In my humble submission, we have done the inquiry not to find out whether her caste certificate was correct or not. We have started the inquiry to find out whether the conduct of our inquiry personnel are correct or not. There is a difference.
No, but is there no notice issued to her about the caste certificate?
Now we have issued.
You have issued.
After the finding, after the inquiry. Initially, what we have done, we are in the process of complying it.
No, correct. Mr. Saikia, there is a reason why this question has been asked.
Lordship.
These are legal issues. We have to be very
Absolutely.
clear. If you think that you can go ahead with an inquiry process, even despite the division bench judgment, then you go ahead. Why should we interfere in the matter?
That is one part. That is one part, Lordship.
No,
that part-
legally speaking.
Yes,
legally.
I'm legally submitting, Lordship. That option is already open for us. We could have closed the inquiry in January itself.
So that's what we are asking. Then what is the need for the review?
Our need for the review is very clear. Suppose we come to the conclusion that certificate is not correctly given to her and we are cancelling it. Again, we have to come for a review.
Why?
We have to come for a review.
So far as regarding the, before the learned single judge, the question was regarding the validity of the decision of the state level committee, whereby it is refused to grant a caste certificate.
Lordship.
The division bench has upheld that decision of the learned single judge has said that he has rightly set aside the learned single judge has rightly set aside the decision of the state level committee of not granting certificate to her. Now, if as per the state is competent to initiate further inquiry into the caste certificate of the private respondent, and they can very well cancel that certificate in the event if they found that it is a fake certificate or whatever. Maybe you go ahead with this. Where is the question of review?
Yes, in that case, I will withdraw the review,
Yeah.
but I will place my contempt appeal because there is a contempt sword hanging on my head.
That's another part.
These are interlinked. These are interlinked,
That's another
Lordship.
part. In contempt,
I'll be more than, I will be more, in fact,
in contempt, it is open for the contempt to demonstrate before the court that there is no willful
Absolutely.
disobedience on his part, that's all.
we tried it hard and very vehemently, we tried that,
Then-
but we
then-
could not convince the learned single judge.
That, then we will hear that appeal against the contempt order. But what about this review?
I
If
fully
the
agree,
state
Lordship.
is confident that they can initiate a further inquiry.
I'll be more than happy, whatever has fallen from Lordship's mouth, I'll be more than happy to carry out that.
Sir, Mr. Sekia,
But
please examine this issue. It's not a very simple issue. See, if you want to press the review, then you have to annul your process of second inquiry against her. Or if you want to proceed and think that that second inquiry is legitimately permitted, then the review will
then
not be
Lordship will
maintainable.
kindly adjourn this matter.
No, what I'm saying is, don't
Yes,
take a
I'm
rush
sorry.
decision.
I'm sorry.
Because these things have a very, you know it. This is a keenly contested matter. We will have to, the state's arguments are formidable. The respondents will also come up with formidable argument. We'll have to deal with it. And when we get down to such nitty-gritties, we will have to go by the fine prints of law.
Absolutely, Lordship.
Therefore, we want to give an opportunity to both sides. See, you may be right in saying that subsequently we got hold of materials which raises aspersion or questions the integrity of the caste certificate. Therefore, we want to file a review to recall that order of division bench and rehear the matter. That you may be justified in taking that plea, subject to what they may say. But the point is, ultimately, if you succeed in the writ appeal, all you can do is you can proceed with or conduct an inquiry against her. And if you find that the caste certificate is not valid, cancel it. After cancellation of that, she has to be served with a notice why her service should not be terminated. These are the processes which perhaps legally that will flow.
Yes.
But if you have already initiated that process despite the
Our
division bench
process
order-
is regarding the verification of the caste certificate, nothing beyond that. It is not regarding her termination of her job.
Can
What-
you
What
do
my,
that?
what my lord is suggesting, sir, that if you are so much confident that you can initiate a second inquiry despite the order of the division bench, then go ahead with it. There is no question of review of this order. And if you are coming with this, that since on account of this division bench order, we can't initiate or complete the inquiry, further inquiry in relation to the caste certificate, then for whatever you have done or initiated inquiry, you may you withdraw all this and then wait for the decision of the division bench in this writ appeal.
It's a little tricky situation.
You can't have both the things in.
So my humble submission is very clear. Whatever, taking a cue from Lordship's opinion now, till now, that let this whole matter be adjourned for 4 weeks. In the meantime, they have already responded. We'll complete the inquiry. And after that, the final outcome, because this is no, we'll not take a decision
In
now.
that case, you are admitting that the state is. fully
If suppose
competent-
it
the
is
state is fully competent to conduct a fresh inquiry.
Lordship,
This
which
is
we
your
have done.
stand is, if
We
the
have done.
state is so confident that we can conduct the inquiry despite this order of the division bench, you go ahead with it. You go ahead with it. There is no question of review of this order. And if you want that this court may permits you to conduct a fresh inquiry, then in that case, you withdraw that whatever the inquiry you initiated and wait for the decision of this court in this review petition. And if the review petition is allowed in writ appeal, and then proceed further in accordance with law.
But our materials which we have found out on 26 December, whether that will be admissible or not, that is the,
Let me,
otherwise we don't have a ground for review.
so, Mr. Saikia, again,
Anna.
putting it again, what we are requesting you is to think about this aspect and even them. Because of following reason, we find that it is a bit of an oxymoron insofar as the stand of the state is concerned. If you succeed in the review, the writ appeal will be reheard. If you succeed in the writ appeal, you will be allowed to proceed with a fresh inquiry on the validity of our caste certificate and pass an order, right? Now, that is why you want the division bench order to be reviewed. But you have already started that process. So both the things can't be correct. Either you have to come in review, get the order modified, annulled or whatever, tinkered in the writ appeal, and then proceed with the appeal proceeding. Or if you think that this proceeding initiated despite the division bench order is legally tenable, then we cannot hear the review petition. What is the purpose of doing it then?
In
Of
that
course, the
case,
consequences will
there are
follow.
two options open to us according to what has fallen from the honorable bench.
Mhm.
That either we stop this proceeding of review by withdrawing it, or else we withdraw the proceedings against them in terms of the,
That's right.
yes, the second part.
Yes, yes.
Immediately I can say that we'll stop that. We'll pursue this, but the materials are here before this honorable court now.
That's right, that's right.
Then you come with the order,
Yes,
whatever this notice
Yes.
issued to her, withdraw it.
yes.
And
Let,
then-
let there be
That-
2
that
weeks
is better,
adjournment.
that is
Lordship.
better. Otherwise, it becomes untenable for the court also.
Till the 7th is
You
over,
can't have both the order.
I fully-
Things,
Lord.
continuation of review.
I am
and the
submitting before that,
inquiry.
we are going to close that, stop it, withdraw that notice, so-called notice, and we'll come before this honorable court.
No, don't drop it, just withdraw it.
Withdraw
In
it.
view of the.
No, withdraw it. That is what that 28th so-called notice.
That's right.
The review petition.
Lordship.
Then it becomes an open canvas.
Absolutely.
Otherwise, like, you
I put-
allow the review, we'll go for proceeding. If you
Every
don't
day is a learning
then-
process, Lordship. This angle we never thought. So let the matter come after 7th of.
You are smiling, Mr. Patwari. also.
No, no, I will,
Both.
I am happy he's not here. Otherwise, all the
In fact,
missile
they
would have
both,
come to me.
You both are smiling and we are in trouble.
You wanted to post it after 7th.
After 2 weeks, Lordship. Maybe 13th or 14th.
Yes, but Mr. Patwari, we must tell you that his arguments that the inquiry was conducted in a perfunctory manner. If it is established, then the matter will have to be reheard. Be ready with that. If it is established.
We don't think. Update before your lordship, what is already on record. Nothing.
In fact, his argument is that whatever the material now they are placing relax was not available for the division bench.
That means so it was already available on the, before the honorable single in the division bench as well.
His inquiry reports, the further inquiry, everything.
Very good was not there, but the document submitted along with the inquiry report, those are always there. That is a big.
That's why only what is their case is that despite having all these documents, this inquiry officer or that vigilance officer has given a false report. This is what your case, the case is.
I don't want to disclose my business right now, but it's already on record.
You have to ultimately disclose it before us.
Definitely we will.
You can disclose it now.
What do you want to hide from us?
I'm actually sorry, man. It's at a relevant point of time. Sir.
Okay.
When my time.
Okay.
13th or
These
14th.
matters- These matters for further hearing.
16th. 16th May?
If it-
Twenty-first May.
Lordship. Highly obliged.
Deeply appreciate.
Interim order if I need to continue to the next stage.
Item 16.
May I?
I am appearing for the respondent number 6, Lordship. I am appearing for the respondent number 6, Lordship.
Spot
Yeah,
number
Lordship.
6.
Respondent 6, Lordship.
Yes.
Lordship, yeah, here I am assisting Mr. Air. We are Lordship. Due to personal difficulty, he has left the full Lordship.
My lord,
Lordship,
on the
adjournment,
last
Lordship.
3-4 occasions, my lord, it came, my lordship, but hearing could not happen, my lordship.
So what do you want? You are objecting to it?
Yes, my lordship, I may be heard, my lord, it can be kept apart because several times, my lordship, the matter could not be heard and it was left over, it was left over. My lordship.
Thursday? On
That's
Thursday?
Okay.
Thursday, this week Thursday.
Yep, yep.
Item 17.
This matter will need some time. Can be, if the go is for the other side, standing council held. It can be on 9th or 14th, considering that it's an admission matter.
9th.
9th. Problem.